Welcome to everybody. Good afternoon from Istanbul. The presentation, next presentation is from Associated Professor Faruk Kerem Giray from Istanbul University. The topic is a very interesting one. The effects of corona pandemic to the residence and travel rights of foreigners and rethinking the definition of refugee. Please, Professor, could you please start?
Thank you for moderators. I guess many of the participants remember me from the other sessions. Professor Sezer honored me to act as a moderator for 2 sessions, and now I have the privilege to make a speech on this session. So first I want to share my screen. So I think, is everything fine? So I think everyone now see the presentation. So my topic is the effects of COVID-19 pandemic to the settlement and travel rights of foreigners. And also when I decided to talk on this subject, I also consider the definition of refugee as well, because they have the right also the settlement and travel rights. So that's why I want to consider this subject as well. What are the contents of my speech is the legal basis of settlement rights, especially in national level and also in international level, and also the legal basis of travel right, in other words, freedom of movement as well. And also I will consider may freedom of settlement considered as a right of foreigners or not, because we may consider that it can be a right for citizens, but it can be considered as a right for foreigners or not. Maybe it can be discussed. And can foreigners travel or move freely in a state? Also needs an answer to this question. And what are the legal bases of restrictions on COVID-19 to secure public health? And lastly, may someone rely on COVID-19 pandemic to be considered as a refugee? I mean, is that an option that can rely on this pandemic? And so rethinking on the definition of refugee. And so I want firstly give my speech on the legal basis of settlement rights of foreigners. What are the related provisions is, the firstly I want to mention the provisions of the Turkish constitution. It brings equality and non-discrimination regulated by and secured by Article 10. Brings equality and non-discrimination on citizens and foreigners. So this Article 10 covers this non-discrimination both for citizens and also for foreigners. And dealing with the settlement right, Article 23 regulates this right and says that everyone has the freedom of residence and movement. So there isn't any restriction for foreigners or for citizens. So everyone covers all people in the country. And the second paragraph of the Article 23 regulates the restriction of this freedom. And it reads that the freedom of residence can be restricted for 4 options. One of them is for the purpose of preventing crimes, for the promoting social and economic development of the city, and also for achieving healthy and orderly urbanization, and also for protecting public property. What we see in here is there isn't any restriction regarding the consideration of public health or public policy, something like that, but it covers only 4 restrictions. And Article 16 is very important in Turkish constitution, because the fundamental rights and freedoms for foreigners can be restricted by law compatible with international law. This is, I think, very important, because the citizens of Turkish people, the rights and freedoms of them cannot be restricted by considering international law. I mean, yes, Turkey is a member to European Council, Council of Europe, so maybe the European Court of Human Rights decisions and also the convention binds Turkey and Turkish people. But when the restriction occurs regarding with the rights and freedoms, the government must take care international law and international conventions when make a restriction. So it writes in Article 16. And sorry. Article 9 is an also important one. It writes, sorry, if the law concerning fundamental rights and freedoms differs from the provision of the international conventions that Turkey become a party, then the provisions of international agreements will prevail and apply at first. But this only covers, as you see, I put it marked in a yellow one, just covers with the fundamental rights and freedoms. I mean, in other cases, rather than fundamental rights and freedoms, the law of the state will apply. But if the convention, the provision of the convention regarding the fundamental rights and freedoms differ from the internal law, from the national law, then the convention provisions will apply at first. And what is the effect of the international conventions in Turkish law is international agreements, conventions are, when put in the effect, have the force of law. Another legal basis for settlement right is law on foreigners and international protection. This is somehow a new law, we can say, because as you know, the Syrian refugees, whenever came to Turkey, Turkish legislation didn't cover all this situation. So that's why new law must be made, and this is the law on the foreigners and international protection. And law on foreigners and international protection, Article 54 and paragraph C, is also important subject, but I will tell later. The first one is foreigners who intend to stay in Turkey beyond the duration of a visa or a visa exemption, or in any case longer than 90 days, must obtain a residence permit. I think it will be similar in all states, in European states. So residence permit is a must in order to intend to stay in Turkey if you stay longer than 90 days. And also a special permission is given in Article 27. If you have a valid work permit or issued or a document that work permit exemption confirmation is issued, then it will be considered as a lawful residence permit as well. And Article 31 reads that foreigners who intend to receive medical treatment, provided they do not have a disease posing a public health threat, may grant short-term residence permit. But the important thing is if you want to apply to Article 31, short-term residence permit, you don't have a disease. I mean, if you have a disease after getting the short-term residence permit, it differs. But for considering the Article 31, you don't have a disease when you apply for the short-term residence permit. And the other legal basis of settlement right of foreigners is also the directive on the application of law on foreigners and international protection. This directive also covers, and also the law covers, the humanitarian residence permit as well. This is also new. It comes to Turkish foreigners law with this code. And the provision says that it can be given due to emergency or in extraordinary circumstances. So if a foreigner caught COVID-19 illness, infection, so he or she can apply to do a humanitarian residence permit. So this is an option for foreigners. And also we have a directive on temporary protection, and just considering the Syrian refugees. I'm using the term of refugee for Syrians, but this is not legal. This is not lawful. We consider them in Turkish legal system as their situation is temporary protection. I mean, the government didn't give the status of refugee, and we will talk later, and also conditional refugee to the Syrians, just give the situation as a temporary protection. So the Syrians, for the Syrians, their legal situation is regulated by temporary protection. And it reads that temporary protection identification document will grant the right to stay in Turkey. So if the Syrians have the temporary protection, so they will grant the right to stay in Turkey. But there's an exception for this. This document will not deem to be equivalent to a residence permit, or we substitute residence permits as well, and also will not grant to transition to long-term residence permit as well. So it just grants the right to stay in Turkey, not to consider it as a residence permit. I think this will be a problem in some way regarding to their legal situation as well. And law on habitation is a special law or code in Turkish legal system, and it regulates residence permit for a special kind of immigrants. So for this, in order to benefit from this habitation law, you must have having a lineage from Turkish blood, and you must have a loyalty for Turkish culture, and coming to settle in Turkey. So these three options, conditions must be set together. So the government then grants the habitation right to them. So when we talk with the international convention level, the first one is the Universal Declaration of Human Rights of United Nations, and Article 13 says that everyone has the right to freedom of movement and also the residence with the borders of each state. So according to Universal Declaration, everyone, doesn't matter whether he's foreigner or a citizen, has the right of freedom of movement and also have the right of residence, settlement right. Also, the other one direction of this right is that everyone has the right to live in a country, including his own, and to return to his country as well. So it is secured by the Universal Declaration as well. One of the important convention for us is the European Convention on Establishment. So states will permit contracting states to travel freely within its territory without contrary to public policy, national security, public health, or morality. So, when the states party to the European Convention on Establishment, so the general rule is they will travel freely within its territory, especially for 3 months, according to the regulations, but it can be restricted due to public policy, national security, or public health or morality. So we can use when for the COVID-19 disease people, we can restrict their travel due to the Article 1 concerning public health. And also Article 2 reads that by considering their economic and social conditions, states will facilitate the prolonged or permanent residence in their territory for the nations and other states. So according to their economic and social conditions, the convention grants the right to prolonged and permanent residence permit as well. And the other legal basis of settlement right is the bilateral agreements. Turkey has made many bilateral agreements between Turkey and other states. I just write them. There isn't any special cases for this. I mean, when I write this with Romania or the Egypt, doesn't matter. They are especially the same provisions. And when we consider these provisions, I mean, when we consider these bilateral agreements, we see that there are 3 criteria that this bilateral agreements consider. One of them is respect to the laws and regulations of the state. So when a citizen, I mean the Romanian or the Egypt citizen, wants to travel to Turkey due to this bilateral agreement. So he must or she must respect to the laws and regulations of the state. And this freedom is based on reciprocity principle. So this is very important. And also all these agreements say that they can benefit from the most favored nation clause as well. What are the questions regarding with this issue? Whether the settlement is a right or permission for foreigners, and whether the traveling is a right or permission for foreigners. Because I mean, we can see that yes, settlement is a right, but is it for citizens or also covers for the foreigners as well? So this is important, I think, in some way. So what does Turkish constitution say? And we, as I said before, everyone has the freedom of settlement. So when we use the definition of the term of everyone, so it covers the foreigners as well. But also it covers that there's a restrictions on for this freedom, and it regulates in Article 23, paragraph 2. So when I consider in Turkish law, settlement is a right for Turkish citizens, with no doubt. I mean, because it is listed in chapter 2 of the constitution that regulates, I mean, the title of this chapter is rights and duties of the individual. So the government concerns that it is a right. I mean, we must consider that it is normal, because I mean, even if you want to have electricity in your home, or if you want to open a bank account, so you need to be a residence permit. So this is important. So settlement right is considered as a right, and also it's secured by Turkish constitution. So we must also consider Article 10 and Article 16 together, because Turkish constitution Article 10 says that there is no discrimination between the foreigners and also with Turkish people. They are all together, and we don't have any discrimination concerning their race, their age, their sex, their gender. So it was secured by Article 10 of Turkish constitution. And Article 16, again, I made reference to this because when I restrict the rights and freedoms of the foreigners, so Article 16 of the Turkish constitution is the basic principle, and it says that yes, you may restrict the rights and the freedoms of foreigners, but it must be compatible with international law. So you must consider the international law and the provisions and the especially the conventions as well. But as you will see, it says that compatible with international law, not with the saying that international conventions. So if Turkey doesn't become a party or doesn't sign or ratify any convention, maybe it can be considered as a part of international law in some way. Is settlement considered as a right of permission? When we consider that European Charter of Human Rights, Protocol number 4, Article 2.1, but Turkey is not ratified this protocol. Turkey has signed this protocol, but not ratified. So it is not entered in the force of Turkey. And article reads that everyone lawfully within the territory of a state will have the right, freedom to choose his residence. So when we consider for the foreigners, yes, the residential right is also considered as a right, not for a permission. And freedom of movement, when we consider about the freedom of movement and traveling rights, and it also said that everyone lawfully within the territory of the state shall within that territory have the right to liberty of movement. So this protocol also secures the liberty of movement, the traveling right as well. So it grants, so we can say that the liberty of movement, I mean the traveling right is some kind of right that was secured by the European Convention on Human Rights. So concerning about the Protocol 4 of European Convention on Human Rights, we have a case, this is İletmiş versus Turkey case. And in this case, the court observes that the applicant had been living in Germany for 17 years and had come there at the age of 22 and studied at university and had got married there, and his 2 children had born there, and that the whole family lived in Germany. So where both spouses were employed and social workers as well. And the court considers that the criminal proceedings lasting 15 years infringed the reasonable time guarantee embodied in Article 6 of the Convention for the Protection of Human Rights and Fundamental Freedoms. And the court considers also that the confiscation of a passport by administrative authorities and the failure to return it for a number of years was a proportionate interference with the right to family life under Article 8 as well. So, and what it writes in the decision of the court is that it writes that the fact that the freedom of movement is granted as such under Article 2 of the Protocol number 4, and which Turkey has signed but not ratified, because Turkey says that, yes, and it's the true argument for it. But the court said that it is irrelevant given that one and the same fact may fall more than one provision of the convention and its protocols. So in some way, the European Court of Human Rights considered the other provisions when related to the Article 4 of the protocol. Freedom of movement and traveling rights also regulates in Article 23 in the first paragraph of the Turkish Constitution, and it was also restricted by the 23 and paragraph 3. So, as you will remember, Article 23 regulates 2 rights. One of them is the residential, the settlement right, and also it covers the freedom of movement. So I raised the right of settlement when I write here, because I just write that everyone has the freedom of movement, but also the article writes that it has the freedom of settlement as well, but I just showed you in a section. That's why I raised the resident settlement permit, right of settlement. So freedom of movement may be restricted by 23 paragraph 3, 23 paragraph 3, for the purpose of investigation, for the prosecution of an offense, for the prevention of crimes. So in here we have just only 3 options, 3 criteria. For the restriction of movement, it is just for the purpose of investigation, for just dealing with the criminal matter, for the prosecution of an offense, and for the prevention of crimes. So again, what we see that is there isn't any restriction regarding the consideration of public policy, public health. So it isn't written, it wasn't regulated in Article 23. And for Turkish citizens, freedom to leave the country can be restricted only by the decision of a judge based on criminal investigation on prosecution. We can say that it is also a guarantee for foreigners as well. So regarding with the conventions as well, what does the Refugee Convention say regarding with the settlement and the right of movement? So because Turkey, as you know, is a member to the Refugee Convention as well. And the convention says that the contracting states, I mean the states, will grant to refugees lawfully in its territory, so the right to choose their place and residence. So states must grant this to the refugees to choose their place and of residence, to move freely within its territory, and by considering any regulations applicable to aliens, generally in the same circumstances. So Article 26, especially any regulations applicable to aliens, is a safeguard for also refugees. I mean, Turkey, I will speak later in the other pages of the presentation, but what can I say that is, Turkey reserves a geographical limitation to the Refugee Convention, but if we forget in somehow, as you see, the Refugee Convention is a very strong legal protection for refugees. That's why Turkey didn't want this situation to the Syrians and considered as a temporary protection. But again, Turkey has a geographical limitation reservation as well. So we can say that refugees have the right to choose their place of residence in that state, and also to move freely as well. And we have also signed and ratified the Stateless Convention as well. After this huge number of Syrians came to Turkey, so Turkey ratified this convention. Before this Syrian war, Turkey is not a party to the Stateless Convention. But afterwards, Turkey signed and ratified this convention. And what does the Stateless Convention say? It is very similar. I mean, all the provisions are nearly the same. And you will see that Article 26 is the same wording, the same article number. So it says that, again, but just for the stateless people, the right to choose their place of residence and to move freely in its territory. And also, again, by considering any regulations applicable to aliens, generally in the same circumstances. So other important conventions but must be considered in especially regarding with the COVID-19 epidemic is the International Covenant on Civil and Political Rights. You will see the entry into force. It stands for entry into force. Why? Because I will tell another convention. It is dated in 1966. That's why I prefer to use the entry into force date in order to make distinction of the convention and covenant. Article 2 says is the main principle, says that each state undertakes to respect and to ensure all individuals within its territory and without distinction of any kind, such as race, color, sex, language, religion, political or other option, national or social origin, property, birth or other status. So this is the same, this is the main principle securing for the aliens and also for the signatory parties. And Article 12 is an important article provision for our subject. It says that everyone lawfully within the territory of the state shall within the territory have the right to liberty of movement and freedom to choose his residence. So Article 12 grants both liberty of movement, so they can freely move, and also they have the right to choose their residence. So, but paragraph 3 of Article 12 also plays an important role, and it restricts these rights, and it says that these rights shall not be subject to any restrictions except those which are provided by law and necessary to protect the public order and public health, and also goes on. So public health can be taken for the restriction of these rights according to Article 12. So Turkey is a party to this convention. So Turkey can apply this provision, Article 12 and paragraph 3, in order to restrict the right of the foreigners to travel and settlement right in Turkey due to public health. So this is an important provision of the convention, of the covenant. And the interpretation, this covenant, Article 12, is interpreted by the Office of High Commissioner for Human Rights in 1999. So I want to tell about this interpretation. And this High Commissioner says that if a foreigner who entered the state illegally, but whose status has been regularized, must be considered to be lawfully for the purpose. I mean, if the foreigner entered the state Turkey illegally, but then it considered and made all the legal transactions in order to stay in Turkey legally, then the High Commissioner says that you couldn't deport this person regarding that he entered the state illegally. So the right to move freely relates to the whole territory of a state, including all parts of federal states. I mean, so you must open all the states to you, not just consider only one state. And according to article, again, in 12 paragraph 1, persons who are entitled to move from one place to another and to establish themselves in a place of their choice. So they can move and also their change of their residence as well. The enjoyment of this right must not be made dependent on any particular purpose or reason for the person who wants to move or stay in a place. I mean, you must just restrict these rights only by considering the paragraph 3 of this article. So it says us that. And also, when regarding to interpretation of this article, states must always be guided by the principle that the restriction must not impair the essence of the right. I mean, the main article is Article 5 on this, and so it says that this restriction must not impair the essence of the right. So it is protected by the covenant. So the relation between the right and the restriction, between the norm and the exception, must not be reversed. Restriction measures must conform to the principle of proportionality according to the interpretation. So they must be appropriate to achieve their protective function. They must be the less instructive instrument amongst those who might achieve the desired result, and they must be the appropriate to be interest to be protected. So the principle of proportionality has to be respected, but not only in the law, so by the administrative and judicial authorities as well. So it was specially written there that the administrative and judicial authorities said also must respect this right. And the application of restrictions in any individual case must be based on clear legal grounds and meet the test of necessity and the requirements of the proportionality. So this is the main structure of this article. And the application of the restrictions also needs to be consistent with the other rights granted in the covenant and with the fundamental principles of equality and non-discrimination. So, when you make the interpretation of this Article 12, you must also consider the equality and non-discrimination principle. And it will be a violation if the courts or judicial authorities or the administrative authorities didn't consider this criteria. So regarding the right of movement with a country, the committee has criticized provisions requiring individuals to apply for permission to change their residence. I mean, if the government's administrative authorities ask the permission to change their residence, so it says that it's against the law. And if the government, the administrative authorities seek the approval of the local authorities of the place of destination, or it's kinds of delays in processing such written applications considered as a breach of this right. Other kinds of obstacles may be if payment of high fees for this movement or for residing can be an restriction of this can infringe this right, and also unreasonable delays in issuance of travel documents as well, and restrictions on family members and traveling together. If there's a restriction on that, again infringes the Article 12, and it's the protect secure. On the other hand, the condition could be met by the restriction on access to the military zones or national security grounds, so it can be accepted. I mean, you couldn't travel in these areas, so it was interpreted in this way. And another, I mean, regarding with this convention, International Covenant on Civil and Political Rights, every human being has the inherent right to love, to life. So we must consider this, I mean, freedom of movement and right of settlement with the Article 6, which covers protects the inherent right to life. So because why I'm considering this? Because by considering the COVID-19 effect, you must consider and you must protect the right to life of the people in the state, whether they are citizen or foreigner, doesn't matter. So the duty to protect life implies that states parties must take all appropriate measures to address the general condition in society that may eventually give rise to direct threats to life or prevent individuals from enjoying their right to life with the dignity. So these general conditions may include the prevalence of the life-threatening diseases such as AIDS, malaria, or also the COVID-19 effect as well. So when we consider this covenant, Article 6 must be put in mind as well and must be considered together. So the other convention, what I highlighted in a yellow is, you will see the previous convention is International Covenant on Civil and Political Rights. I mean, one of them is, the name is International Covenant on Civil and Political Rights, and the other one is the same title, International Covenant on Economic, Social and Cultural Rights. So the titles changed, but it's very similar. That's why I highlighted in order to make the distinction between these covenants, between these conventions. And this is again a 1966 convention, so that's why I write the entry into force date of this convention. And this is the main important article of this convention is Article 12. And it writes that the states parties to the present covenant recognize that the right to everyone to enjoyment of the highest attainable standard of physical and mental health. So the parties, the states, must must protect the physical and mental health of the citizens and the foreigners in their country. And also the steps to be taken by the states parties to the present covenant to achieve the full realization of this right shall include necessary what are important regarding the COVID-19 epidemic is the prevention, the treatment and control of epidemics. So in this convention, what we see is the use of term of epidemic is first used. I mean, so it is regulated in it is drafted and regulated in 1966 and entered in the force 1976 because of the parties, states become party to this covenant. But in this covenant, it was clearly written that the treatment and control of epidemic can be the restriction for traveling right of the foreigners and also the citizens. So this paragraph C plays an important role for this covenant. Another important paragraph is the paragraph D, and this is considers the creation of conditions which would assure to all medical service and medical attention in the event of sickness. So the government must also grants all medical services and medical attention for epidemic, for any kind of sickness. So that is why this is a must, this is an obligatory for the states that signed and become party to this convention. So let's talk about the restrictions to settlements and movement. Regarding to Turkish civil code, what is the definition of settlement? What is the definition of residence? So it was regulated. The definition of settlement is regulated as a term in Turkish civil code. Article 19 regulates this, and it writes that settlement place is the place where a person intends to live permanently. So if the intent is temporary, then it won't be considered as a residence. So the main issue is the person who intends to live permanently, especially for Turkish law, there isn't a special duration for this, but 6 months, considered as intent to live permanently, we can say that. Maybe more than 6 months. A person may not, because before, if you, less than 6 months, it will be considered as an habitual residence rather than. A person may not have more than one settlement place at the same time, according to Turkish civil codes. And also, you can change the settlement place. And so there is no obligatory transaction for this, but just you inform the administrative authorities that you made a change on your residence. Why it is important? Because if there's an action brought against you, so they use the residence address for you that you declare when you apply in residence permit. And where a person has an unknown settlement place, and this is also used for foreigners as well, provide a settlement place in Turkey, even though she leaves the previous settlement place in abroad, then the current residence of that person is regarded as his or her settlement place, including foreigners. So the previous settlement place is considered as a settlement place. Article 20 of the Turkish Constitution says that everyone has the right to demand respect for his or her private and family life. Privacy of private and family life shall not be violated. So the choice of residence, the choice of place to settle is also dealing with the right of private life. So that's why in some way it covers this right. So I just want to mention this right in here. And regarding with the private life, it also secures and covered in European Convention on Human Rights, and the rights that everyone has the right to respect his private and family life, his home and his correspondence. So when a restriction comes to settle or freely movements in a state, we must also consider the private life of the citizens and the foreigners, and also being a party to the European Convention on Human Rights, Article 8 must be considered as well. And for the special codes, law on foreigners and international protection, I have mentioned Article 31F. It says that foreigners who intend to receive medical treatment, provided they do not have a disease posing a public health threat, may grant short-term residence permit. I mean, I mentioned this before in the pages in this presentation. But Article 54C is important. If a removal decision, can be given, if the foreigner submits untrue information and false documents during the residence permit actions. So it is important. I mean, if the foreigner gives untrue information to the administrative authorities or gives false documents to the administrative bodies, then the administrative authorities can give a removal decision against this person. And Article 55 is an secure provision for this removal decision, because Article 55 says that a removal decision shall not be issued, shall not be given in respect of those foreigners if the one faces risk due to the serious health condition. I mean, if someone causes COVID-19 infection, then the Turkish government, Turkish authorities couldn't give a removal decision because of he or she gives untrue information or false documents. So Article 55 is a secure provision for removal decision. I mean, it's an exception. We can say that it's an exception. And paragraph C for Article 55. Again, the person who will not be able to receive treatment in the country to which they shall be returned while undergoing treatment for a life-threatening health condition, again, is the exception of removal decision. So if the foreigner says that or intends that I couldn't able to receive treatment in my country if you return me, and due to the COVID-19 pandemic. So again, administrative authorities couldn't deport or grant removal decision against him. What is important about this Article 55 is, maybe you can say that, I mean, it can be in the grants of administrative authorities, but by regulating clearly in the code, in the law, so it secures, it guarantees, it safeguards for the foreigners, especially for having COVID-19 infection. About the internal law, again, I just want to mention Article 23, paragraph 2, just concerning the freedom of residence. Again, we see no restriction for considering the epidemic or public health. So, I mean, the administrative bodies couldn't use this article when removing or when deport someone due to having COVID-19 infection. And also we can see it in the for the right of movement or free movement. Again, Article 23, paragraph 3 again doesn't have any option for the restriction due to COVID-19 or epidemic or any kind of disease or public health. So these are not guaranteed by these articles in Turkish constitution. What can we consider? Which articles could we consider? Is Article 19, because everyone has the right to personal liberty and security. So the government, again I said, must secure the right to personal liberty and security both for foreigners and also for Turkish citizens, because as I said before, Article 10 regulates non-discrimination for all the people living in the country, in Turkey. So no one shall be deprived his or her liberty except a person spreading contagious disease to be carried out in institutions when such persons constitute a danger to the public. So it is a safe provision for foreigners as well, because it considers a person spreading contagious diseases. So we can see that it can be a part of epidemic disease, COVID-19. And the constitution of Article 119, in the event of outbreak of dangerous epidemic disease, it is just written like that, the President of the Republic may declare the state of emergency in one region or nationwide for a period of not exceeding 6 months. I mean, as you see, it is written clearly in 119 of the Constitution article. But for now, I mean, during the COVID-19 duration period, the president doesn't use this right and doesn't declare state of emergency. Article 17 has the right to life and the right to protect and improve his or corporal and spiritual existence. So it is also dealing with the right of securing his health. So we must consider Article 17 as well. And Article 56 deals directly with the public health. So the provision secures that everyone has the right to live in a healthy and balanced environment. So in order to ensure this right, to sustain this right, the government can make exceptions and restrictions on the residential right and movement right inside the country. And for the Turkish criminal code, it regulates the punishment for if people doesn't obey these rules. Restrictions on the settlement right and movement in internal law, and also the other decisions are on the law on villages. And according to Article 88, foreigners who want to settle in villages must get permission from the Ministry of Interior. In Turkey, if a foreigner, I mean, bought a house in a village, then if he wants to get a permission, residence permission for residing in here, so he or she must apply to the Ministry of Interior in order to get permission for to settle here, to settle there. And also another restriction is military forbidden and security zones law. And according to Article 7, we have a first degree military zone and second degree military zone. Well, it differs for Turkish citizens, but regarding to our subject for foreigners, it doesn't make any sense. It doesn't make any change. Foreigners cannot enter or settle in these areas, whether it is the first degree military zone or whether it's a second degree military zone. When we consider the public health law, it's a very old, one of the old law of Turkish nation, and it says that Article 57 lists number of diseases But as you will consider, this, I mean, in this list, modern epidemic diseases are not written, such as Ebola, SARS, COVID-19, etc. So regarding to this issue, Turkish Constitution Court in Halime Sarı Aysel application considers that these listed diseases are as considered as numerous clauses. So this thing, I think this is a problem in some way for Turkish law. And Article 64 is a guarantee for, I think, for administrative bodies. If another disease spreads out rather than listed in Article 57, yes, that is the COVID-19 places in this situation, the Ministry of Health must inform the spread of disease in which cities and regions are affected, and also must take necessary measures for preventing this spread by law compatible with the public health law. So the important thing is the Ministry of Health in this case must give information and also must take all necessary measures if it is not listed in Article 7 listed disease. Article 72 considers three types of person whose right or travel or movement will be restricted. These are the patients. If there's a doubt on his or her illness, I mean, doubt is enough to restrict their travel and movement. And also the ones who carries the disease and spreads it by the determination of technical investigation. And the code writes that the technical investigation. So we understand that the medical doctors made this determination. So what we see is there will be no infringement of constitutional rights for this group of people having COVID-19 infection. I mean, if we consider Article 72, so I mean, then the government, the administrative authorities can easily take these measures, take these steps for these people. The time limit for this restriction is determined by law as sufficient duration determined by the science. So this is important. I mean, so the time limit is the sufficient duration determined by the science. So it will be again by the medical doctors. Will be determined for as you know, I mean, in the same, maybe in the whole world, for the COVID-19 incubation period is determined as 14 days at most. Regarding to the quarantine situation, there is an important decision given by the European Court of Human Judgment, European Court of Human Rights. It is Quimo and Russia application. This is the only case in which the application of a quarantine has been considered by the European Court of Human Rights. And according to the court, restriction should be a temporary measure and to be discontinued as soon as circumstances permit, so that severe and lasting restrictions, a long duration, are particularly like to be disproportionate to the legitimate aims pursued. So what we say is the restrictions must be ended insofar as the circumstances permit and must be proportional. So these are the criteria that Turkey also must consider when applying the quarantine and the quarantine process in Turkey or in some region. So this is an important case and decision for Turkey to be considered. Provisional administration law, why I highlighted it in yellow place, because our restriction for movements or settle, I mean, outside in other places rather than our residence, our home, is based on Article 11, paragraph C of the Provincial Administration Law. And it says that the government takes all necessary decisions and measures in order to sustain peace, security, and public well-being inside provincial borders. So, I mean, as I said before, the president doesn't decide to use the emergency power, but it uses, I mean, the Ministry of Health uses this Article 11 and takes all necessary decisions, so makes restrictions on the movement inside the country, in somehow in all cities, in some way in part of the cities, in some cities. Places for isolation. According to Article 72 of the Public Health Law, persons who carries disease can be isolated whether his or her home or in health units, hospitals or units having technical equipment. So restrictions to the settlement right in international law. Everyone has the right to liberty and security of person, and no one shall be deprived of his liberty, save in the following case and in accordance with the procedure prescribed by law, especially the lawful detention of persons for the prevention of the spreading of infectious diseases. So again, in Article 5, in E section, it writes that the spreading of the infectious diseases is a restriction for the right to liberty and security. Regarding to interpretation of restriction by European Court of Human Rights, these are the ENHON criteria. So it's a well-known criteria used for the restriction. And the court finds that the essential criteria when assessing the lawfulness of the detention of a person for the prevention of spreading of infection disease are whether the spreading of the infectious disease is dangerous to public health or safety, or whether the detention of the person infected is the last resort in order to prevent the spreading of the disease. So the two criteria is dangerous to public health, and also it is the detention, the isolation is the last resort for preventing the spreading of the disease. So you can, if you take less severe measures that have been considered and found to be insufficient to the safeguard or public interest, then you infringe the Article 5 of the European Court of European Convention on Human Rights. European Court of Human Rights also considers that by extending over a period of almost 7 years the order for the applicant's compulsory isolation, with the result that he was placed involuntarily in a hospital for almost 1.5 years in total, the authorities failed to strike a fair balance between the need to ensure that the HIV virus did not spread and the applicant's right to liberty. So, in this decision, in this application regarding to the ENHORN, the court gives violation, founds the violation of Article 5 in this application. And regarding the Turkish Constitutional Court's interpretation on deportation reasons, and it's a very nearly dated decision, and it says that applicant's daughter who tries to divorce is subject to violence from her husband, so that she needs the care of her origin family. And the court ordered that an order for deportation will infringe the right to respect family within the context of Article 20, paragraph 1 of Turkish Constitution, and also Article 8 of the European Convention on Human Rights. So, if there's a violence from husband or from family members, even if he stays or she stays against the law, he breaks the law for residing in Turkey, and the court ordered that you couldn't give a deportation decision for the people who is living in this situation. So, as a summary for Turkish citizens, we can say that Provincial Administration Law Article 11C will be applied. For Public Health Law Article 72 will be applied. And for foreigners, for their settlement and freedom of movement, Turkish Constitution Article 16 must be considered. And also the two conventions, International Convention on Economic and Social and Cultural Rights, and also International Convention on Civil and Political Rights must be considered as well. Medical treatment and vaccine, maybe it's not dealing directly with my subject, but just want to say for 3 verses related for that. When we use see the Constitution of Article 17, we say that the corporal integrity of the individual shall not be violated except under medical necessity. So the application of vaccine is can be considered legally in case of it is a medical necessity. And regarding with this situation, we have an Constitutional Court's decision, Halime Sarı Aysel application, and it is the family members didn't want to make a vaccine to their daughters, so the court, I mean, so the first courts ordered that it is the violation of public health. So the Constitutional Court ordered that, I mean, regarding with this issue, says that, I mean, this is the infringement of Article 17, because according to Turkish Constitutional Court, compulsory vaccine is a kind of medical treatment, so it is against physical integrity of a person. And regarding with the vaccine, BOFA and others in San Marino application can be considered as well. And according to this judgment, the court ordered that where individuals have objected to vaccination on the basis of religious or belief, the European Court of Human Rights has explained that while Article 9 protects persons' personal beliefs and religious creeds, and acts linked to such beliefs, it does not always guarantee a right to behave in the public sphere dictated by such a religion or belief, and the term practice in the article does not cover every act motivated by religion or belief, because in the section the person rejected the compulsory vaccination due to his religional beliefs. But the court says that in terms of vaccination, specifically, the obligation to undergo vaccination applies to everyone, regardless of their religion or belief, and so it does not constitute an interference with Article 9. Rethinking on the definition of refugee, but I think I'm speaking much more, and Professor Sözer also told me that we can take questions. So I just maybe answer the questions about the refugees or rethinking on definition on the rethinking on the definition of refugees later. So thanks for consideration.